Hi, we'll talk now about products liability. Products liability is a subset of a category of torts called strict liability. Strict liability is sometimes called liability without fault. So everything we've learned so far about torts is you're liable if you did something you shouldn't have done, if you did not behave like a reasonable person, if you intentionally caused harm to somebody else, then you're liable under tort law because you shouldn't have done it and you knew you shouldn't have done it. That's true in tort law in all cases except strict liability. Strict liability is a doctrine that is designed to meet some public policy concerns. It doesn't especially have to do with a particular defendant having been in the wrong. And this is why it takes a leap of understanding for you to understand the rule. We're taking a pretty simplified approach to this tort simply because of time. But products liability is the most important tort that falls within strict liability. It's the one that comes up most often in business, and it's a tort to be really aware of as you look at managing liability risks for your company. Why do we have a tort that can hold you liable even if you did nothing wrong? How can that be? Again, there are public policy reasons for this. One idea of this is that it will increase public safety. There are many countries in which public safety is something that's simply regulated by the government. In this country, obviously, we have many laws of regulating product safety. However, the notion with products liability is that those in the business of selling a product probably have superior knowledge about the product's safety and use than do outsiders, including the government. And why not put, this is the thinking, why not put the burden on those in the business of distributing a product to make that product as safe as possible? Therefore, even if there is not a particular regulation affecting the manufacture or distribution of a particular product, someone in the business of distributing that product could still be held liable if they have violated the standards of products liability. It puts the burden on the people in the business of selling that product, and it gives consumers greater rights. In addition, especially in the global economy, you have to be able to get jurisdiction over a company in order to sue them. Suppose that you buy a product in the United States, but it was manufactured in some foreign country. It may be that you cannot get jurisdiction over that manufacturer because they're not doing business or having any meaningful contacts in the United States. You won't sue them in this country. There are some abilities to sue companies to some degree in their home countries, but that's a matter of international law. You're making it much more difficult for consumers to sue and much less likely that they will sue simply because of the complications and the expenses involved. The idea in general is to put the burden on those who are benefiting from distributing that product, even if they didn't do anything wrong. If you are in the business of distributing a product, sooner or later someone's going to allege that they were injured by a defect in your product. As an intelligent business person, you must realize that that risk exists. And if you're smart, you're going to plan for it. How do you plan for it? Well, get insurance for one thing. Work it into your distribution contracts. When you buy products that you're distributing, or when you sell to distributors, put provisions in there of indemnity. I'm sorry, you're listening to a cat fight here. The notion of indemnity means reimbursement. So indemnity both applies to insurance, because if you have an insurance policy, the insurance company has agreed to indemnify you, reimburse you, if you suffer a loss within the meaning of the policy. But indemnity agreements can also come with between parties. So, for example, if you're a distributor, you may want to enter into an agreement with the manufacturer saying, you agree to indemnify me if I become liable as a result of distributing your product. So, in other words, the idea is put the burden of loss on the parties who are both benefiting from distributing that product, and secondly, who have the ability to plan in a business sense for that liability risk. Now, again, this is a simplified version of the rule of products liability, but it's for our purposes, we're good. Here's the rule. Anyone in the normal chain of distributing a defective product is liable for damages caused by that product. Okay, so we've got it in one sentence, and now we just need to know what the words mean in that sentence. Let's start with product. A product is something that is designed, it is manufactured, it is produced, it is grown, it is distributed. What a product isn't is services. So you're looking at simply a product, not services. If you go to your accountant for tax advice, that's simply not a product. So products liability will not apply to it. We're looking only at products. You bought a car last year, that's a product. This computer you're looking at right now, that's a product. So distinguish product from services. Secondly, defective. This is something that gets litigated a lot. Again, to be pretty simplistic about it, defective for our purposes means it does not meet a consumer's reasonable expectations of safety. Defective does not mean that it caused harm to somebody. If that were the rule, then you couldn't sell knives, for example, because we've all been cut by a knife. So it doesn't mean that it can cause harm. It means that customers' reasonable expectations have not been met in the safety of that product. So a regular, well-designed, well-manufactured knife is not defective. A poorly designed, poorly manufactured knife that breaks off, that's defective. A second thing to look at with defectiveness is not just the product itself, for example, in a knife, it can also include the packaging that a product is in. So, for example, you bought a bottle of beer and it was improperly sealed and it blew up and shattered in your face and you lost your eye. Sorry, that's kind of awful hypothetical, but I had a case like that once. It's not the beer that was defective, it was the packaging, it was the bottling of the beer that was defective. So far we have the product itself, the packaging could be defective, and finally, the instructions for the product could be defective. And that's actually fairly often alleged, that the product itself wasn't defective, but the way you instructed me to use the product was defective. So look at the way that people have instructed consumers to use particular products. Was that adequate? Did it meet a consumer's reasonable expectations of safety? If you've ever looked at some products, well, take a look at a ladder, for example. You know the little shelf that that's available for you to put paint on or something. There's typically a sign there saying, caution, this is not a step. Does the ladder manufacturer think you're stupid? No, but someone somewhere along the way has actually stepped on that thing and fallen and hurt themselves. And arguably, the ladder manufacturer does not want someone to come back and say, you didn't instruct me on the safe use of this ladder, you didn't tell me that little shelf wasn't a step and that I couldn't step on it. So they're trying to make the ladder as instructions as safe as possible. Finally, be careful. This law is counterintuitive. You're naturally going to want to say, well, but if someone did nothing wrong, why should they be liable? I'm telling you to get past it. Whether you agree with it or not, or whether I do or not, is irrelevant. This is what the rule is in this country. I've worked with a lot of foreign companies over the years, and this one is a struggle for many companies from other countries. They do not understand how they could end up being liable for a defect they didn't cause simply because they were in the chain of distributing that product. Nevertheless, that is the law in this country. Here's our first example taken from a real case. The names, of course, are all made up. Suppose your friend Tatiana was at your house. She drank some of the milk that you offered her. At the bottom of the milk carton, you both discover part of a dead mouse. Now, suppose that Tatiana got sick and that she can prove it was drinking the tainted milk that made her sick. Okay, now first, before we get any further, when a problem tells you to assume something or suppose something, just do it. Don't argue with it. I've sometimes had students saying, well, Tatiana didn't prove that the milk made her sick. You're missing the point of the question. You're actually trying to avoid answering the question on an exam. If the question gave you facts and said, assume these facts are true, then the question's getting at something else, not for you to be argumentative about what the facts are. The facts are being presented so that you will debate a legal issue. Don't overthink this. If the case tells you Tatiana got sick and she can prove it was the milk, go from there. Okay, now you, and let's say that your name is Mohammed, you bought the milk from a local store called Hale's Grocery. Hale's got the milk from MK Inc., a milk distribution company. MK bought the milk from Allied Farms, which is a milk processor and packager, and Allied bought that milk from Garcia Farms, which is a dairy farm. So the chain of distribution looks like this. Garcia sold it to Allied, Allied sold to MK, MK sold to Hales, Hales sold to you, Mohammed, and then you gave the milk to Tatiana. Assume that an investigation shows that the milk was contaminated with the mouse at Allied Farms during the packaging process. In other words, when the milk left Garcia Farms, it was fine. The problem occurred at Allied. Assume also that MK and Hales did not tamper with the milk. It was at the point of Allied that the problem occurred. Who's liable to Tatiana under the doctrine of products liability? Is it Allied because they were the ones who were negligent? They're the ones who allowed a mouse to get into the milk during the packaging process. Is it Garcia, Allied, MK, and Hales? Or is it Garcia, Allied, MK, Hales, and Mohammed? Okay, now if you're answering A, it's logical and wrong. What you're looking at is more like a negligence theory of whose conduct was careless, causing harm to someone else. But we're not talking about negligence here. We're talking products liability. Go back to the rule. Anyone in the normal chain of distributing a product is liable for a defect in that product. A is wrong. Now between B and C, the only difference is whether or not you, Mohammed, are liable. Why is Mohammed, you, different from the other people in being listed as defendants? Because Mohammed is an incidental purchaser of the milk. He is not in the business of distributing milk. In fact, Mohammed, in this hypothetical, did distribute milk to Tatiana, but he's not in the business of distributing milk. Therefore, Mohammed will not be liable. For products liability, we're trying to encourage, as a policy matter, certain kinds of behavior from people in the business. Mohammed's not in the business, so the correct answer is B. Okay, let's talk a little bit about defenses to products liability. They are really the same as they were for negligence, and that is contributory or comparative negligence, depending on your jurisdiction. And review that podcast if you need to on the distinction. But the point is, did the plaintiff's conduct cause or increase the harm of their injuries? In other words, is the plaintiff in whole or in part at fault in causing their own injuries? very commonly alleged in products liability cases. For defenses, look at contributory or comparative negligence. Did the plaintiff's conduct cause or increase the harm of their injuries? Whether it's contributory or comparative negligence, remember it depends on your jurisdiction. If you want to review that concept again, go back to negligence 3 so you can hear the distinction between the two. But in both cases, you're looking at the plaintiff's conduct. Did she do something that increased her own injuries? The second defense, and again, just like negligence, is assumption of the risk. This one is very commonly alleged in products liability litigation. And that test for that is, did the plaintiff, number one, know or should she have known of the risk? And number two, did she voluntarily undertake that risk? Now, as you analyze products liability cases, and actually all tort cases, always start with the tort, then move to defenses. What your instinct will be to seize on what you think is going to be outcome determinative. So if you get a case where you think there's, let's say, assumption of the risk, you'll often jump to that without establishing whether the tort even occurred. But on an exam, your professor wants to hear, do you understand what the tort is? Do you understand what the elements are? And if you're jumping to what you think is going to be what determines the outcome, you're not going to have that discussion. And you have not demonstrated that you know about the tort. Similarly, you're missing another problem, which is you may be missing issues. And if you at least go through them methodically, you're more likely to catch something that isn't that obvious. So start with the tort, move to any defenses you think might apply. Do you get more credit on an exam for discussing one issue very thoroughly, or several issues but without as much depth as you would prefer? Which one's going to get you the higher grade? The latter. Most law exams are issue spotting exams. The professor's trying to see, does this person see what the problems are? So make sure that you're going through things methodically, have an outline in mind. For example, in a negligence case, be sure you know the 4 elements of negligence and the relevant defenses and be able to go through those. Here's another example. Haesung versus Bolts. Suppose that Haesung bought a circular saw at Bolts. Let's suppose that the saw was designed and manufactured and sold by Bolts. Let's assume that it's a single entity here, just for simplicity's sake. Haesung removed the safety guard so that the saw was more versatile, but unfortunately cut off a finger while using the saw. Suppose that Haesung can prove that many consumers remove these guards and that Bolts designed the guard to be easy to remove so as to please customers. So there was a safety guard on there. The safety guard was very easy to remove, and Haesung did remove it. What is Haesung's best argument that Bolts is liable under products liability? Well, Haesung's best argument would be not that the saw was defective itself, because saws are designed to cut things, and in fact the saw did cut things. Unfortunately, it was Haesung it cut. Haesung's argument would be that the safety guard was defective because it was so easy to remove. Now I know this sounds like a push, but you will sometimes find cases where people say it was deliberately manufactured and designed to make it easy to override the safety mechanism. And that's defective because it doesn't meet a reasonable expectation. I'm not saying Haesung is going to be successful. I'm saying that's Haesung's best argument. What's Bolt's best defense? Well, certainly you would want to talk about assumption of the risk. Would a reasonable consumer know that there's a risk in removing a safety guard? And is that consumer reasonably assuming that risk? Is that consumer voluntarily assuming that risk? Certainly that's a strong argument for Bolt. In addition, you could argue that Haesung himself was negligent. So contributory or comparative negligence, depending on your jurisdiction, that it was negligent on Haesung's part to remove the safety device and that Hae Sung's negligence caused his injury. Should you talk, which one of those two defenses should you talk about? Both. Show your professor everything you know. If they both apply, talk about both of them. Okay, so in sum, realize that products liability is by far the most commonly sued upon tort that falls under strict liability, that there are significant liability management impacts on companies doing business in the United States, and this is something to think about as a business person, both in terms of the contracts you enter into, products you choose to sell at your place of business, along with insuring against the risk of loss. Okay, that's it.